guys, thanks so much for listening. I hope you guys get a lot out of this. We are going to go over the exclusive right to sell listing agreement, which I hope means you guys have it coming soon and you're just needing to get some paperwork done. We'll probably go into more detail than what you all want to know, but the more you know, the easier it is to answer questions when your seller actually has them. So tune in, and I hope you guys get a lot out of this. All right, guys, this is the TAR RF 101 exclusive right to sell listing agreement, designated agency. If you need to know more about the designated agencies, you can listen to the confirmation of agency document that we have up. But as for right now, let's go ahead and get started. So this first section right here is just about the company, right? You work at Keller Williams, so we're going to put Keller Williams, 450 St. Andrews Drive. Here's the owner information. Um, you're going to put the seller's first and last name, but you're also going to ask them where they actually live, because sometimes what you're selling and where they live are two different things, because it could be an investor and they're selling other properties, right? So make sure you ask that. In consideration of the broker agreement to find a ready, willing, and able buyer and other valuable consideration, the receipt and sufficiency of which is hereby acknowledged, the undersigned seller hereby grants the broker the exclusive right to sell the hereinafter described property in accordance with the following terms and conditions. So this is saying, hey, after we get through this document, these are all the conditions that we are going to follow. The property address is right here, so you're going to fill all that out. This right here you can find in the tax records. If you have any questions about that, you can ask anybody on the office where that number is. This is everything that is included with the property, so just make sure you read through those. I think sometimes the ones that stand out the most where people have issues with are the mirrors, because some mirrors you can actually take off the wall. The shutter, blinds, and shades, and curtains and draperies. I feel like the curtains are a big one, and the draperies we've had some issues with. And then the TV mounting brackets. Everything else is usually pretty self-explanatory, and people usually don't have issues with those, but those are the ones we run into the most with. So read through those, make sure that you know what actually belongs with the house. Other items that remain with the property at no additional cost to the buyer, let's say the swing set, they don't want to take it with them, so they're going to go ahead and leave it there for your buyer, right? Items that will remain with the property or will not remain with the property, maybe they do want to take their curtains, so they're going to put those there. Leased items, so your security systems, water softeners, I put propane tanks, that's another one. Ask that specific question, because if they do have leased items, they may want to take them with them, or they may want to cancel their subscription. And some houses have propane tanks that actually you have to have for it to actually run the heat, right? So make sure you actually ask the right questions there. The listing price, you understand that. And then this right here is, it basically says that once everybody signs a document, it's a valid document, and you guys can start marketing the property. It also gives you a expiration date for this property. If you want to market the property at a later time, you're going to put or and put this August, whatever date you need to put in there. Moving on to page 2, the carryover clause. That is for your protection. If the listing expires, what's going to happen after that? So if the listing expires, but a buyer comes back and wants to purchase the property, if it's your procuring cause or not, the seller is still saying, hey, if it's within these days, we're going to go ahead and pay you. So whatever date, or not date, whatever days you want to put in here is totally up to you, right? So some people put 30, some put 15, some put 60. You're going to have to run it by your sellers, of course, too. And so you put whatever times or dates that you want to put in there. I always put 30. It does say that if it gets relisted by another real estate agent and it goes under contract, you are not getting paid. So just be aware of that. Possession of the property to be delivered, I always put date of deed, which is the day of closing. We've had a lot of issues with people not educating their buyer or seller what that actually means. They actually have to be out of the house before they go sign the documents and close on it. if it's date of deed. So make sure to educate, educate, educate on that. Some people, some sellers will ask for temporary occupancy agreement. If they do, one of my suggestions would be is to put it into realtor remarks. And that way the buyer's agent and you can negotiate the temporary occupancy agreement before you guys actually go under contract, because it will relieve some headaches later on down the road. Because what if you go under contract and then you guys want to negotiate the temporary occupancy agreement, but nobody can agree to the terms and conditions of that, right? So my suggestion is to kind of talk that through, and then you can send the offer with the temporary occupancy agreement attached, negotiate all that, and be done with it. Terms of the sale acceptable to seller. You'll need to look some of this stuff up, guys. The FHA, VA, RD, cash, conventional, and I don't know why I did VA twice, but not all houses qualify for rural development, so you're probably going to have to go to their website to check it out. Not all houses qualify for FHA and VA. So just make sure you're using the right loans for whatever the house will qualify for to go under contract. Compensation. When you're negotiating compensation, you're not only negotiating it for yourself, but you're also negotiating it for the co-op agent. So this is the total amount of commission that the seller is going to pay to get his house under contract. Keller Williams does not have a set commission price. We usually get 6%, but at the end of the day, it's up to you to negotiate that with your client. In the event that the property is leased under the terms of this agreement, you can put a number here or here. Maybe it's just a flat fee or a percentage. I mean, that's whatever you want to do. It also goes into detail on how you're going to actually get paid on this. So I recommend, if you do want to do leases, that you go ahead and read through those things, right? And also, the property itself, the seller has a emotional tie to it. But if they do decide to lease it, make sure that the property is offered without regard to race, creed, color, religion, sex, handicap, familial status, or national origin. So no discrimination, right? At the end of the day, they need to know that. They don't know all of our laws and guidelines that we follow. This next little section, it's talking about our compensation and what happens if the seller chooses not to close on the property after we've produced a ready, able, and willing buyer. So it says that in the event that a ready, willing, and able buyer is produced and contract results, the seller is obligated to compensate broker in the event that seller unlawfully, right? Unlawfully, so it's not just anything, unlawfully fails to close or fulfill lease terms by seller's breach of the purchase and sale agreement or lease agreement. If this occurs, seller agrees to compensate broker in an amount equal to the compensation which would have been due and owing broker had the transaction closed or the lease been fulfilled. Such compensation will be payable without demand should the broker consent to release the listing prior to the expiration of the term of this agreement or any extensions. Seller agrees to pay all costs incurred by broker to market property or other amount as agreed by the parties as a cancellation fee. One of the things I highly recommend is if you guys want to enforce this, please put it in your listing agreement that if this contract gets terminated early because of both parties, that X amount of dollars will be due to marketing. Don't leave it blank. I would definitely put a number in there. In addition to any other sums that may be due to broker, seller agrees to pay all reasonable attorney fees together with any cost and expenses which real estate firm incurs in enforcing any of seller's obligation to pay compensation under this listing agreement. So it's just a protection for you guys to make sure that if we did our work and everything is ready to close and the seller just pulls out, that no matter what, you guys are going to get paid. Responsibilities and rights of the parties. This little section right here is going to talk about the MLS. So this is basically saying that the seller is granting us permission to put it into our MLS, which is our multiple listing services, which is RealTracs, and that once it hits RealTracs, that it could syndicate out to a lot of different other websites. So when you get to the end of putting a listing into RealTracks, there's a question at the end. Do you want to go ahead and send it out to the Zillows, the Realtor.coms, the other agents' websites, or do you just want to keep it into RealTracks? Of course, we want to be able to send that out to the world, but there may be somebody, a client of yours, that does not want the whole entire world to know that they have a listing for sale. So be aware of that and just know that you do have an option there. But this is actually talking about, hey, once we put it into MLS, it's going out into the World Wide Web. Seller agrees that the listing may also appear on public accessibility websites sponsored by or affiliated with the MLS, the local association of realtors, or similar listing services, and those lawfully receiving listing information from said entities. Broker shall provide timely notices to MLS of status changes, shall use best efforts to produce a buyer, and may divide compensation with other real estate licensees. So we're just saying, hey, we negotiated 6%, 3% goes to us, and then 3% goes to the local MLS agent. So that would be somebody that works for a different company, but they also have access to RealTracks, right? We're offering that 3%, it needs to be somebody that's working with a buyer, and they should be either a facilitator, a selling agent, a designated agent, whatever that may be. He or she will be the procuring cause, which means they showed the house to the buyer and they're ready to make an offer, and that's the person that if they go under contract, that's the person we're going to pay. So we also have another option right here, which is the 3%. This 3% right here is for another Tennessee agent that isn't part of our MLS, right? So the first 3% was for the RealTracks agents. This next 3%, maybe they're out of Knoxville or maybe they're out of Chattanooga. They're just not part of our MLS, but they still have their license in Tennessee, so they still can sell our Tennessee homes. So one of the first things I want you guys to do, if you have a person that is not another realtor, right, that is wanting to show your house that is not part of RealTracks, so they don't have access to our Sentry boxes, please go to tnverify.org and make sure they have an active license, because you're going to give them a temporary uh, code to get into this house. Well, you're responsible for letting people in and out of that house. So please, 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 please make sure that they are actually an agent and you're giving an agent the code and not just anybody. Um, so this next section says that we're going to let the seller know if it's not a realtor from our MLS, but somebody from a different MLS that still has a Tennessee license. Um, in the event that the broker shall notify seller in writing that the cooperative compensation is being offered to the non-member participant agent. Seller will assist broker in any reasonable way in selling property and will refer to the broker all inquiries regarding this property during the term of this agreement and any extension or renewals thereof, and authorizes the broker to provide final sales information to MLS for the purposes of compiling comparable sales data reports. More things that we're going to do. We're going to put a sign and lockbox on the property. We can remove any old signs that were there previously. We're going to go ahead and give out any kind of disclosures that are necessary for the state of Tennessee. I also suggest that if there's a personal property, personal interest disclosure and confirmation of agency, you would add those as well. You need the Tennessee property condition disclosure or exemption. The easiest way, or the lead-based paint disclosure, the easiest way to do that is to upload these to our MLS, and so that other agents have access to them right away. If you're working with a co-op agent that does not have access to RealTracks, I would go ahead and just email those documents to them. Some agents actually leave the documents at the house and the agents take them from there, but I don't like printing out a ton of extra documents. I don't think it's necessary, but if that's what you prefer, you're able to do that. It also says that we're going to take video of the exterior, interior. We're going to have audio recording possibly for any advertising material, and we'll be distributing that and promoting the property. So it just gives more information about that. It also states that in the event that seller provides photographs, videos, or copyright materials that the seller grants brokers a non-revocable license to such photographs, videos, or copyrighted material, and that we can go ahead and use those without getting sued. Seller shall allow the property to be shown at all reasonable hours and otherwise cooperating with the broker. Seller agrees that the broker is authorized to receive on behalf of the sellers all notices, offers, and other documents incidental to the offering and sale of the property, which is covered by the agreement. Seller agrees that such receipt by the broker may be deemed to be the receipt by seller if such documents so provided or if the law requires. So once you guys get these documents, your time clock is ticking because you're stating that you are going to be the one receiving those documents for the seller. Seller agrees to keep broker informed of all seller's whereabouts in order for broker to promptly forward all such notices and offers and other information to the seller, so that, of course, we can go ahead and get back to the buyer's agent. In response to inquiries from the buyers or cooperating brokers, broker will follow seller's lawful instructions on the disclosures of the existence of any offer and disclose of terms and conditions of any offer. So just make sure that when you're getting these offers that you are sending them straight to your seller and negotiating those offers. Foreign investments in real estate property tax act disclosure. So this is all black. So make sure that you're asking this question, hey, do you have any foreign investments? If they do, just send them to their attorney or to their tax accountant, and they can get anything cleared up there. Examples that of this may include if the seller can be classified as one of the following: non-United States citizen, non-residential alien, and foreign corporate partnership trust or estate. So if you know of any of those, you may want to ask a couple of extra questions. Section. It's the hold harmless and limitations on broker authority and responsibilities. This is basically saying that the seller should be giving us all true information, and that if it's not, that they don't hold us responsible for any harm caused to the home or the person purchasing it. But let's kind of dig a little bit deeper. First part is seller agrees to carefully review the information of the multiple listing profile sheet and complete either the Tennessee property condition disclosure, disclaimer, or exemption. So the first thing that I do is once I have the listing in MLS, I actually send that sheet, I make it a PDF form and send that sheet to the seller and say, hey, can you review this for me? Make sure that everything looks good. So that way I have physically sent them something that is in black and white form, and they send me something back saying, absolutely, it looks great, or hey, Tammy, you messed up. Can you go ahead and fix this? So that is one of the first things that you need to do once you have the listing up in MLS. And I would not skip over that. The next part basically says that we're going to give them all the documentation, the lead-based paint disclosure, all those forms need to be filled out properly, and any kind of defects need to be reported, right? So if they have any knowledge of anything, it needs to be put on one of these forms. If they do not disclose something and we do not know about it, it's basically saying that they do not hold us responsible for that. It says seller is not aware of any other defect or environmental factor which would affect the value of the structural integrity of improvements on the property or the health of future occupants. Seller agrees that seller shall be solely responsible for any misrepresentation or mistakes on the listing data wherein seller has supplied such information on the attached multiple listing profile sheet. So that's why I actually like to get that sheet sent out and back, because I did supply them with the information and I actually asked to make sure everything's correct. And again, we're going to have all the extra documents that we need on RealTracs so that the buyer or the buyer's agent can pull those. Seller further agrees to hold agents and firms harmless and indemnify them from any claim, demand, action, liability, or proceedings resulting from any omission, alleged omission, or misrepresentation by seller on said forms, or for any material fact that is known or should have been known by seller concerning property and is not disclosed by agents, and to provide for defense costs, including reasonable attorney fees for the agent and firm in such an event. Seller is not aware of any other defects, environmental factors, or adverse facts concerning property. You guys, if they're not sure if it should be on something, just disclose, 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 disclose. That is the best thing to do to make sure that we are all following the laws and guidelines and making sure that everybody is safe and no lawsuits can arise when you're having everything disclosed that needs to be disclosed. So just make sure you guys get all the correct paperwork filled out and make sure that everybody has access to those. So, as you all know, we live in the digital age, and there's a lot of people recording information right now, especially during um, open houses, during showings. So, if your seller is wanting to do those things and see how it's black again, black is always super important, right? So, sellers responsible for compliance with state or federal laws regarding usage of video or audio recordings devices while marketing or showing the property. Sellers should seek legal advice regarding their rights or limitations related to their actions. So again, just make sure that if they're going to do any recordings, that they are following the state laws. Next little section, it usually surprises one or two people. It actually surprised me too because I didn't know. So, first of all, seller authorizes broker and his affiliates to do open houses and showings. They also are saying yes for us to be able to have a key and to allow co-op agents to access the house with the key and put a lockbox on the house. Those are all normal things, but it's just reiterating, hey, we are able to do these things. Seller represents, here's the thing that usually surprises people. Seller represents that adequate insurance will be kept in force to protect the seller in the event of any damages, losses, or claims arising from entry to the property by persons through the above use of the keys and agrees to hold brokers, its licensees, salespersons, and employees harmless from any loss, theft, damage incurred as a result of showings, open houses, or other authorized entry therefore. So, what does this mean? This means you need to talk to your clients to make sure that they have enough insurance on their house. So, if anything happens during the open houses or the showings, or even the broker's open houses, that your seller is covered because it's not our responsibility. Acknowledges and agrees that the broker may show properties to prospective buyers who are interested in the seller's property, which means we can show them this property, but we can show them other properties as well. We're not just stuck on this one single property. Here's some more disclosures that we are not experts with regards to the matters that could be revealed through a survey, title search, hazards or toxic materials, square footage, zoning. I mean, it's a whole slew of, hey, these things we're not experts in. With destroying insects. So, seller acknowledges that the broker is not an expert with respect to the above matters and is hereby advised to seek independent expert advice on any of these matters which are of concern to seller. So, one of the things you need to make sure of is just to have a vendor list, right? If they want to do a pre-termite inspection before putting the house on market, have three termite companies ready to give them if they don't know anyone. But always make sure that you have a minimum of three and just don't send one because if things go south, you're the one who picked it for them. Does that make sense? Um, shall owe no duties to the seller or have any authority to act on behalf of the seller. This is basically just saying you're the real estate agent and that's it. You're selling their house. Do not do extra things such as personal things because that is a different type of relationship. You are they're your clients, right? So have a professional client relationship. May make all disclosures required by law, and we already kind of went through all those disclosures. There'll be more videos of the different disclosures that we require. Expert assistance. This is going to hit it kind of out of the park. We've already talked about this, but it's again stating that we have considerable knowledge of the real estate industry, but we are not experts in any of these other matters, such as square footage, home inspections, wood destroying insects, etc., etc. If broker provides names or sources of such advice or assistance, broker does not warrant it or guarantee the services or products obtained by the client. So again, it's protecting you, but also make sure that you go ahead and send the three referrals out. It's not just one person that you're sending out because that's how it can come back to you because you're the one who gave them that one name. So always try to have three vendors, three termite inspectors, three mortgage lenders at hand so that they can't say, hey, she only get or he gave me one. Um, we always do that as well. And if you go to our Keller Williams Murfreesboro page, there's always people recommending vendors. So go ahead and get that list together and make sure that it's ready to rock and roll when you do need these guys. As follows. If you want to go deeper into definitions, listen to the confirmation of agency. I will go over these, but it'll be just an overview. So the broker is me. The brokerage is Keller Williams. Designated agent for the seller, that is whoever represents the seller wholeheartedly and has their best interest at heart. Facilitator or transactional broker means that you're not an agent for either party, you're just facilitating the transaction. If you do decide to facilitate and you're dropping from designated agent to facilitator, you need to fill out documents and notify everybody involved that you are no longer a designated agent and that you are facilitating. If for some reason the deal falls apart as you are facilitator and you're going back to designated agent, you have to fill out the appropriate paperwork. There's paperwork attached to everything. Just remember that. Dual agency means that you're representing both sides. We do not dual agency with Keller Williams. It is not illegal in the state of Tennessee. We just don't do it as a company. Um, Adverse facts. Is there structural integrity? Um, is there a health risk? Those are all adverse facts. Confidentiality stays for until either parties pass, and even after passing, it's still you have to keep whatever you guys decide confidential if your clients asked you to. Now we're going to go duties owed to all parties to a transaction. So this is the buyer's agent, the buyer, it's everyone, right? To diligently exercise reasonable skill and care, providing services to all parties to the transaction. To disclose to each party to the transaction any adverse facts of which licensees has actual notice or knowledge. To maintain for each party in a transaction the confidentiality of any information obtained by the licensees prior to disclosure to all parties of written agency agreement entered into by the licensees to represent either parties or both parties in the transaction. This duty of confidentiality extends to any information which the party would reasonably expect to be held in confidence, except for information which the party has authorized for disclosure or information required by law to be disclosed. This duty survives both the subsequent establishment of any agency relationship and closing of the transaction. Always keep everything confidential. And I'm reading these is because this is our job, guys. So it's important to provide services to each party to the transaction with honesty and good faith. Number 5, to disclose to each party to the transaction timely and accurate information regarding market conditions that might affect such transactions only when such information is available through public records and when such information is requested by a party. Number 6, the timely account earnest money deposits and all other property received from any party to a transaction and to retain from engaging in self-dealing or acting behalf on licensee's immediate family or on behalf of any other individual, organization, or business entity in which the licensee has a personal interest without prior disclosure of such personal interest and timely written consent of all parties to the transaction, and B, to refrain from recommending to any party to the transaction the use of services of any other individual, organization, or business entity in which the licensee has interest or from whom the licensee may receive a referral fee or other compensation for the referral, other than referrals to other licensees to provide real estate services without timely disclosing to the party who received the referral and licensee's interest in such referral or fact that the referral fee may be received. So these are all things that you owe to all parties and not just your client. Owed to your client. So this is in addition to the previous duties owed to everyone. These are additional duties that we owe to our clients. Number 1, obey all lawful instructions of the client when such instructions are within the scope of the agency agreement between the licensees and licensee's client. To be loyal to the interest of the client, licensee must place the interest of the client before all other negotiations of a transactions and in other activities except where such loyalty duty would violate licensee's duty to a customer in the transaction. And three, unless the following duties are specifically and individually waived in writing by a client, licensee shall assist the client by A, scheduling all property showings on behalf of the client. B, receiving all offers and counteroffers and forwarding them promptly to the client. C, answering any questions that the client may have in negotiations of a successful purchase agreement within the scope of the licensee's expertise. And D, advising the client as to whatever forms, procedures, and steps are needed after execution of the purchase agreement for successful closings of the transaction. Upon waiver of any of these duties contained in the Section 11C3, a consumer must be advised in writing by such consumer's agent that the consumer may not expect or seek assistance from any other licensees in the transaction for the performance of said duties. So make sure that you understand what your job is, because it's pretty much right here in this on this sheet right here. On it tells you exactly what we're supposed to do, right? So it's an important section. I know I basically just read it, but take these things to heart, and you'll do just fine. Seller authorizations. Number one, appointment of designated agent. So this is basically saying that we are appointing you, your name would go here, as a designated agent for the seller. Appointment of subsequent designated agent. Seller hereby authorizes the managing broker, if necessary, to appoint a licensee other than the licensee named above as designated agent for seller. We don't do this. If something crazy happened, a passing, something like that, and we would have to change agencies, then or assign a different agent to the seller. That's probably the only time it would happen, or if we feel like it's not a good fit uh, for whatever reason. This would all be extreme cases, guys. We would not just take a listing away from you. So just know that you're the designated agent unless some kind of craziness happens, and then we would talk through that before that would happen. Default to facilitator in the event that both parties are represented by the same designated agent. This is basically saying that this is temporary until you guys close. Otherwise, you need to get back to designated agency, and you have to let people know. So just make sure you disclose that if you're dropping to to facilitator, and then if you need to go ahead and get back to designated agency. Upon any default to facilitator status, the former designated agency must assume a neutral position and will not be an advocate for either the seller or any prospective buyers. Resumption of agency in the event that the designated agent defaults to facilitator status. The facilitator status will only be temporary. The, the facilitator status will only last until any transaction or contemplated transaction in which the parties are all assisted by the facilitator is resolved. At the time, the agent will immediately revert to designated agent status for seller again. Earnest money and trust money. Brokers authorized to accept forms of deposit as earnest money or trust money to be applied to the purchase price of the property. Such deposits held by the broker and an escrow account. I'm going to go ahead and stop there. Keller Williams doesn't do earnest money anymore, so you may want to talk to your title company to make sure that they will hold earnest money for you. I actually put it into MLS that Foundation Title holds my earnest money for me if I have the seller. So just make sure you don't put Keller Williams on there, because Keller Williams won't hold it and you'll have to do an amendment to your listing agreement or purchase and sale, depending. Well, it would be your purchase and sale, because at that time, if there's earnest money involved, you would have a purchase and sale. Title, it's just saying that you're going to give good title. Seller should convey the property by good and sufficient general warranty deed. Home inspection plan, you can select that the buyer has that right out of the gate, or you can negotiate it later. Other provisions, binding effect, entire agreement and modifications and assignments. This agreement shall be for the benefit of and binding upon the parties hereto, their heirs, successors, legal representatives, and permitted assigns. This agreement may only be assigned with the written consent of both parties. This agreement constitutes the sole and entire agreement between the parties hereto, and no modifications of this agreement shall be binding unless signed by all parties or assigned to the agreement. So if you guys need to make changes to the agreement, you're going to have to add an addendum or an amendment. There are more terms here that you guys can read governing law and venue. This agreement is intended as a contract for the listing of real estate property and shall be governed by the interpreted in accordance with laws and the courts of the state of Tennessee. Terminology, severability. If any portion of the provision of this agreement is held or adjudicated to be invalid or enforceable, for any reasons, each such portion or provision shall be severed from the remaining portions or provisions of this agreement, and the remaining portions or provisions shall be unaffected and remain in full force and effect. It's going back over fair housing laws, which we already covered, so you know what that is. Legal document, anything that's 100% bold, we should read through. This is an important legal document, created valuable rights and obligations. If you have any questions about it, you should review it with your who? Your real estate agent? Nope, it says attorney. Neither the broker nor any agent or facilitator is authorized or qualified to give any advice about the advisability or legal effect of this provision. By signing this document, you are certifying that you have read and accept these terms and acknowledge the receipt of a copy of this agreement. That's why it's so important for you guys to actually know what people are signing, because a lot of times they have no clue that they even need to have the proper insurance on the house to make sure that if something got stolen, that they're actually covered. So it is important for you guys to understand this listing agreement. Almost done, guys. So confidentiality. This is information that your seller wants you to keep confidential. Maybe they're getting a divorce. Maybe they're moving out of state, and that would affect how people are going to put offers in. So whatever they want you to keep confidential, you're going to put that into the contract. Exhibits and addendas are all the amendments and addendums that you want to attach as part of the agreement. So your confirmation of agency, your property condition disclosure, maybe they have divorce papers that they want to attach. I mean, they could attach pretty much anything. That's where you're going to write those. Special stipulations. Let's say in the event Mr. Reed purchases property, seller will not pay a commission to the listing agent. So maybe they already had somebody that they possibly were going to sell the listing to. You wanted to go ahead and get the listing agreement signed, so you decided that you're going to put this into there so that they're exempt from you getting a commission if this Mr. Reed comes back to purchase a property. This home is a short sale, and we will need bank approval through U.S. Bank. Contact Lisa Poo. If they're going through a short sale, maybe they need a approval from the mortgage company. Divorce attorney Sean Williams must review purchase and sale agreement within 2 days after binding agreement. If you do have some of this weirdness, you may want to contact, once you start getting those offers in, you could put some of that information into this realtor remarks so that your agents are actually aware that there may be some issues coming down the pipeline. And you can also always talk to the co-op agents and let them know if you think that there's something that they need to be aware of, especially something like, hey, a divorce attorney may need to review the binding agreement 2 days after. So just make sure that you have all your ducks in a row when it comes to that. This would be your guys' signature, and you would put the address of Keller Williams in there, and then your personal information, and then whoever needs to sign the document. We've got 2 sellers. I've had it to where we've had 5 sellers, so I would just create extra boxes at the bottom. So I hope this helped you guys. If you have any additional questions, just let us know, and we'll see you on the next one.